Welcome, everyone, to this symposium's second panel, Using Our Voice, Protecting Voting Rights. My name is Hezzy Smith. I direct advocacy initiatives at the Harvard Law School Project on Disability, and I'm incredibly excited both for this topic and for the incredible group of panelists that we have today. I'll keep my opening remarks brief in order to get to the meat and potatoes of this panel. The right to political participation of persons with disabilities, as we all know, has taken on new salience in recent years, especially in light of recent efforts to restrict electoral access of certain groups across the country. Disability rights groups and their allies have been taking legal action to challenge these new restrictive measures, as well as other barriers to access. And while there have been important victories, there also remain significant challenges. And as we are moving along in this current election cycle, the uncertainties about whether voters with disabilities will be able to participate fully and effectively in these elections is an issue that cannot be understated. So let me introduce briefly our panelists. First, we'll hear from Cheri Mitchell. Cheri has worked for over 16 years at the Georgia Protection Advocacy Organization called the Georgia Advocacy Office, the GAO. And for most of those years, she's served as the Protection and Advocacy for Voter Access Director. She'll describe some of what she and her colleagues at the GAO have learned through their voter education, registration, and monitoring activities, as well as what issues the GAO is monitoring in this current election cycle. Next, we'll turn to Rebecca Willowford, who's the Deputy Director of Litigation and Acting CEO at the Disability Rights Advocates. She'll describe some of their recent voting rights litigation efforts and some of the lessons that they've learned and how those lessons might be applied to safeguarding the rights of people with disabilities in the current environment. Finally, we'll hear from David Hutt from the National Disability Rights Network. David directs and oversees the 12 staff members of NDRN's Legal Services Unit, who provide legal assistance on a range of rights and management issues impacting people with disabilities and the federally created protection and advocacy system. He'll discuss some of the recent legal developments that are directly affecting the rights of voters with disabilities and what's being done to ensure that their federally protected rights to access the polls and receive assistance in casting ballots are fully respected. Each panelist will speak for about 15 minutes on their respective topics. After their remarks conclude, I'll moderate a brief Q&A, and I'll direct your questions that you might submit using the Q&A function in the bottom toolbar or the chat box to them. So I encourage you to submit your questions as we go, and I'll keep track of those before passing them on to our panelists. And so without further ado, Cheri, could I invite you to get us started?
Sure, I would love to. And I'd just like to point out that the Georgia Advocacy Office is a part of the National Disability Rights Network. So as the P&A, the Protection and Advocacy in Georgia, it's important to us to not only reach out to people in the community, but to reach out to those who are underserved, who are at risk, and are the most vulnerable. We want to think about who are the people, what do they need, and how do they need it and want it. We try to identify any barriers that exist and help and support people with disabilities to overcome those barriers. We put a huge emphasis of those people in those segregated and congregated settings. We go out into institutions, sheltered workshops, and nursing facilities to meet the people. We have worked with the DD Network and Centers for Independent Living and ADAPT to host a candidate forum and to also to provide transportation to get people to the polls. And through our supported decision-making project, We work to ensure that people know their rights and that they do have a right to vote and that they get the chance to do that. So we have 6 basic goals that we do. We not only do this work, but we monitor to try to make sure that people are getting the access and being able to vote. So goal number 1 is voter education. We do a train the trainer model training for membership and chapter organizations like People First and the Georgia National Federation of the Blind, because there's only a couple of us. And so we train them and they make sure that that voter education gets out to all their members and to their local communities. So we also do a free training since COVID happened every year on voter education and how important voting is. So some of the biggest knowledge gaps that we see right now is how the new voting laws are affecting Georgians who are trying to vote, including those in those institutions. We're very interested in how these new voter suppression laws are affecting people. And it's also interesting, another big issue that we're running into is that the staff in these places support their residents to try to vote and to register to vote. And they provide a lot of times the voter education and we get to help them. But in Georgia, they can only actually assist 10 people at a time to register, right? So if you have a facility, which most facilities in Georgia have 200 beds, do I need to say any more at the issue here? So we also spend a lot of time educating people that just because they have a guardianship does not mean they can't vote. You know, so we're doing education and we're monitoring and we're trying to help people to overcome all these barriers. So our goal number 2 is voter registration. We use the mail-in voter forms because we're not registered registers. And we promote the online registration. I will say this for Georgia, they do have online registration. I'm still concerned about the accessibility of it, but we do have online registration. So, and then another problem we had in Georgia during the presidential election is that lots of people got dumped off of the voting rolls. And so then we were trying to help people to figure out, were they still registered? So our third goal is go vote. We want people to be able to vote, whether it's absentee ballot or in person. So any problems that people have run into, we have been helping them to file complaints with the Secretary of State and their local election boards. And we start this process by them writing us an email explaining their experience. And because we want the SOS and the local elections board to hear from them directly and hear their voice. So we're doing, you know, as much work as that is possible. Our goal number 4 is that we target those people in those underserved areas. So like I said, we go out to state institutions, we go out to sheltered workshops, we go out to nursing facilities, and we talk to the people at the facility about their experience and the barriers they're running into in trying to support those people. And we also want to try to help address those issues as well. So goal number 5, access and accessibility to voting. We are monitoring for accessibility issues and help people to vote and file those complaints. And during the last election, Georgia got new voting machines. So some of the problems that we heard was, oh, we're accessible. But yet when the people showed up to the polls, nobody there who were working the polls knew how to use them, right? So it's not enough to say, oh, it's accessible. people got to know how to use them so that they can show the voters, right? The poll workers do. So the other issue, in the last presidential election, we went to a two-part voting process. And you start with the machine, you know, and you're able to hear it audible and walk you through voting. But then you print a hard copy and you're supposed to verify that. Well, people with print disabilities can't read it. So they're having to get poll workers or a companion. I even heard a story from one lady that she just had to ask a complete stranger to help her. So that's not people being able to cast a private ballot. So that's just wrong. So, and then we're also concerned about how are people doing the voter registration and the absentee ballots if they have a print disability, if they're only sending paper. So our last goal 6, is voter experience feedback. I don't hear a lot of people talk about this, but I think it's really important. And I think that all these new laws that have come down and the voter suppression that we have seen makes this an important piece of our work. We are part of a national coalition that every 2 years do voter experience feedback surveys. And from those surveys, a report is written on the vote experience and submitted to the Administration for Community Living, ACL. So, you know, I can't emphasize enough how important voting is. These people make the decisions that affect our lives. They decide what programs and services get funded. And it just brings me back to Justin Dart's famous saying that you need to vote as if your life depends on it, because it does. And in closing, you know, I just want to reemphasize the importance of the voter feedback to identifying the barriers that are keeping people with disabilities from voting. I would love to see more people doing those surveys than has in the past. So we need to push, and we need to put this, if you don't already have it as a part of your agenda, it needs to happen. And then the last thing, and I should have talked about it earlier, is the problem with IDs for those people in those congregated and segregated settings. Because a lot of them, in the process of ending up in those settings, lose a lot of their belongings, including their ID. And then getting an ID to be able to vote becomes this really hard process. So again, I want to thank you for inviting me to speak today. And I'm trying to make sure I keep within my limit. But, you know, it's just voting is so important. And it's such an important part of being able to have a voice in what is happening in our lives. Thank you.
Cheri, before you run away, I know that we have talked about, as part of your voter education efforts, clarifying some misconceptions around the effect of guardianship on people's right to vote. And I mean, could you talk about that? Because especially with the new attention and increased attention that people are paying on the to the effects of guardianship orders on a whole array of people's rights, could you talk a little bit about what the GAO is doing in that space to help people who may be affected by guardianship to know exactly what their rights are when it comes time to vote?
Yeah, so we're doing a lot to educate people about the fact that if they have a guardianship, it does not mean that they don't have the right to vote, that it's automatically taken from them. In Georgia, the right to vote it has to be written up in the order by the probate judge, and he has to specifically say that this person's right to vote has been removed. And if it doesn't, you can vote. So, you know, we have been doing that education of people. And I think that's another reason why our supported decision making projects, voting parts is so important, to make sure that people are educated, because supported decision making is an alternative to guardianship.
Thank you, Cheri. And you mentioned also that there are lots of knowledge gaps as the laws around voting in Georgia have changed in a number of important ways. You mentioned voter suppression laws. Could you maybe, without giving away too much of your training contents and that privileged information, could you maybe share a little bit about what you're sharing with voters in your trainings about how those suppression laws might affect them?
Well, the first thing that people need to realize that in Georgia, they reduced the number of early voting days. They've also reduced the places that the ballot boxes can be put. And in doing that, it makes it harder for people with disabilities to access them. Not only that, but the time restraints around absentee ballots has narrowed. And when you're dealing with the US postal system, that's a little hard to make sure it gets there. So we are promoting those absentee ballot boxes as a way to return your ballot and make sure it gets there in a timely manner. But with the restrictions and the narrowing down of where those boxes can be, it's not only made it harder to reach them, but it's narrowed down how many of them are out there, where when they first started this, they were all over the place. So yeah, those are some of the things that we've been facing.
And when you described helping people file complaints about issues that they've had, right? I think it's incredible that you're supporting people to file complaints in their own words, right? But that also poses specific challenges, right? Because if they don't describe the barrier that they're facing in a way that clearly articulates a rights violation, then their complaint might not be as effective. But in any case, I think that's really important. Are there some issues?
What we're doing, Hezzy, is we're including a letter with the email, and we're saying to them, after we were contacted, we spoke to them, and here are the details. And we lay it out clearly in the letter that we write to put with the email. But then at the end, we say, we want you to hear from them directly. So we're attaching the email that they sent us, so that we are making sure that it's clear and that all the issues are laid out very clearly and forthright.
But I think that's really, that's part of the process of empowering people to use their voice in order to protect their own rights to voice, so that, hopefully, you're teaching someone to fish and not just giving them a fish by, filing that complaint for them. And I really think that's a promising practice. Thank you, Cheri. You've been remarkably economic with your time allotment. So I'm going to turn it over to Rebecca to talk a little bit about what Disability Rights Advocates has been doing in this space, and what are some of the lessons that we might take away in the current environment. Rebecca?
Thanks, Hezzy, and thanks, Cheri. You're a tough act to follow, but I'll do my best. Thank you for all the awesome advocacy work that you're doing in Georgia. It's so great to hear about that and to be on the panel together. And thank you to all the conference organizers and everyone at TASH for inviting me to be part of this really important panel today. And just to provide a little bit of background about Disability Rights Advocates, or DRA, where I work, for anyone who's not familiar, we were founded in 1993. So just after the Americans with Disabilities Act was passed by two attorneys and advocates named Larry Paradis and Sid Walensky, and who understood that disability rights are civil rights. And I got into this work because of my own disability. I use a wheelchair and I'm really passionate about disability rights. And I went to law school specifically to do disability rights work, and I love the work that we do at DRA. We mainly tackle high impact litigation, taking on systemic cases to advance equity and inclusion for the millions of Americans with disabilities across all aspects of community life. And our work includes access to voting, which we all know is a critical component of community life at all times. And I think we probably also all agree that a confluence of factors in recent years has served to really enforce how important it is, like that Justin Dart quote. You gotta vote, like your life depends on it. And you got to be able to vote. It needs to be accessible. And so for this reason, DRA is more committed than ever to ensuring that Americans with all types of disabilities have an equal opportunity to vote, which is their right under the law. And we offer a unique and much needed skill set in this area. There's a lot of people working on voting rights generally, which is wonderful. But it's so exciting to be a part of this panel because we're all, doing work on voting rights for people with disabilities, which is, often forgotten in the tapestry of, voting rights across the nation. So ensuring actual access in all forms. And, physical access is very important, but there's a lot more to it than that, as I know this audience understands. And, I'd just like to, just share a little bit about our voting rights work today, and most importantly, how you as advocates can help uphold and advance voting rights in your communities. The cases that I'm going to talk about cases in 3 different states, and they're going to be mostly about people who are blind or have vision disabilities, but the same principles would apply to people with any type of disability. It's the same mechanics, same process you would go through. This is just the tip of the iceberg, the voting disability rights litigation we've done so far. We know there's still many frontiers within this. And also, I'll talk a little bit about, I always like to try to demystify the mechanics of litigation a little bit, because I feel like it can feel a little intimidating, and just wanted to talk a little bit about that. And that's also something that would apply to any type of disability rights and enforcement and litigation. So I'll talk about, DRA's, the tool that we use for, change and empowerment is litigation. So as y'all know, the ADA, as well as the other federal laws, protect the rights of people with disabilities to vote. These laws gave us that right, and really the only channel, if it comes down to enforcing those rights, is through the courts and through litigation. And people with disabilities, aren't born knowing how to take legal action, though, and people who become disabled later in life aren't given a toolkit about how to enforce their rights under the ADA. I know I certainly wasn't, and had to, figure it out for myself, and, fortunately found great, allies in the disability community and various organizations. But I understand the process can be intimidating, and the burden is really on people with disabilities to enforce their rights. So while it can be intimidating, it also can be very empowering, and it's a way for people with disabilities to have their voices heard in very legitimate, very effective ways. The courts are required to ensure that your rights are not being violated, and you don't have to do it alone. People with disabilities play a key role. They're supported by the protection and advocacy systems. I know we've got a lot of folks here from that group. And then there's also a role for people with disabilities who want to be plaintiffs and put their name forward, or to be members in class action suits and share their experience and testimony that becomes really critical evidence in the cases. And every individual's input helps show how widespread the problems are when we're tackling these systemic issues, like entire voting systems that are inaccessible. And we always start when I say litigation, what does that mean? Well, it starts with a letter, a letter to whoever has caused the discrimination. In voting cases, this is often a county board of elections or a state board of elections, and it can vary depending on how a state's voting system is set up. And the goal of the letter is just to work things out if we can. We'd like them to fix the problem, but we also note that if they don't get back to us, and we always give them a deadline, we will, have to initiate a formal complaint in the court. In other words, kicking off a lawsuit, and we want them to know we're serious because we are. So from there, one of two things happens. One is, if we needed, we start turning the gears of litigation, processes like gathering evidence, discovery, and depositions, and that can be a time-consuming process, but we guide our clients through it, and there's lots of support along the way. So the other thing that happens is sometimes we send a letter and an entity comes to the table and says, let's negotiate, let's work something out, and you can work out a great resolution. So those are, it doesn't always have to take years of court battles to get these results. It often does, but it doesn't have to. So again, this litigation is a mechanism for enforcement and empowerment in all areas, including voting. And on that note, I'd like to just share a few examples of DRA's casework in this area. So the first case is about 10 years old, happened 10 years ago in California, in Alameda County, which is where I am based, out of Berkeley, California. And this stemmed from the general election in 2012 of that year and the experiences of blind voters in the county. So on election day that year, Alameda County polling places did have accessible machines as is required, but many blind voters encountered problems with the machines. The machines didn't work properly, and the poll workers didn't know how to resolve the problems with the machines. So these voters had to dictate their votes to other people, which was a clear violation of their rights. And we, pleased to say that resulted in, that was a case where we worked with the California Council of the Blind, and we got a federal court order, affirming that this was indeed a violation of their rights. And we, 3 years later, so it does take some time sometimes, we reached a court enforceable settlement agreement that would ensure that there were revised policies and procedures relating to the voting machines, including testing and functionality of machines before every election, and comprehensive hands-on training of poll workers about the setup of the machines, a dedicated equipment hotline to concentrate on equipment failure issues, and a task force to review and make recommendations. So that's an example of the type of the relief that you can get in these types of cases. Another case was in North Carolina, which is my home state. And I, as I noted, it's not always about the physical access or accessible technology. Often it's about process. So here in North Carolina, leading up to the 2020 general election, North Carolina residents who wanted to vote absentee had to fill out paper ballots and return them by mail. And there was no alternative or accommodation for people to do that independently if they had print disabilities. And this also extended to people with mobility and dexterity issues and learning disabilities. So this policy meant that, despite being in the thick of the pandemic, people with print disabilities could only vote in person. Yet North Carolina's military and overseas voters could receive and return absentee ballots online using a secure system there. So this was clearly a violation of rights of people with different types of disabilities. And here we worked with Disability Rights North Carolina and several other advocacy groups and individual voters who were able to tell us about these problems. And we ended up filing a lawsuit and obtaining a court order granting North Carolina voters access to that system. in time to vote in 2020. And, so last summer there was a subsequent ruling in the case that affirmed that the policy violated the ADA and Section 504. So now North Carolina voters with disabilities can use that online system in future elections. So one last state, jumping up to Indiana, where I have not lived. Indiana has historically had one of the most restrictive absentee voting systems in the country, only allowing blind people to vote at home by appointment with a traveling board of election officials, despite the fact that they could easily vote privately and independently using electronic tools. Again, this was a clear violation of disability rights law, so we set out to change that. And in March, the court in the Southern District of Indiana struck down that rule. And that, again, this rule, in other words, the state policy was that absentee voters who could not independently mark their own ballot could vote absentee by mail only by appointment with a traveling board of election officials. And again, this rule had resulted in at least one voter being unable to cast their vote in the November 2020 general election because the traveling board never came to that person's home. But as a result of, so in March 2022 ruling, voters with print disabilities were able to ask the person of their choice to help them complete a paper ballot in that May 2022 primary. But obviously we must, get the state to do better, and we're still fighting to get relief beyond that May 2022 primary election. So this fight is ongoing, and to ensure equal access for future elections. But we've made progress, and the mission continues. And then I just wanted to talk a little bit about the importance of local partners and the enforcement of orders and remedies. All the cases here highlight how critical it is to work with local partners. For example, as I mentioned, in North Carolina, we co-counseled with Disability Rights North Carolina, which was great. We represented the North Carolina Council of the Blind. And we really, we couldn't have done the case without those local partners. They were telling us what the problems were on the ground. We were bringing the expertise and the voting rights law, but we needed them to tell us what was happening, help identify barriers, and to do that really specifically, because you need that in terms of your evidence in order to build a case and to be able to prove your case. So, DRA only has offices in New York, California, and Illinois. So outside of those states, we need local counsel to assist and guide us and connect and engage us with the community effective. And local partners are the boots on the ground, So, in this spirit, I always encourage folks to, reach out to DRA, reach out to your PNA if you're having issues with voting in your state. And so now I just want to take a couple minutes, and then I'll wrap up to talk about what happens at the end of litigation with the enforcement of orders and remedies. So it's all well and good to have, a lawsuit and a court order saying this voting system must be accessible. But then comes the hard part where the defendants have to actually make the system accessible. And it's our job as the attorneys to be sure that they're doing what they've been ordered to do. So I wanted to talk a little bit about what happens at the end of a case. It's usually one of two things. We reach a settlement and the court signs off on it. Or if there's no settlement, the court will actually order what the remedy is. Either way, we fix a barrier and the court retains jurisdiction of the case. And we get an order, which means that we can always go back to the court if it's not working out. So we get an order of resolution and we agree to a dispute resolution process that allows us to go back to court if needed. This is, very powerful, but in some ways just the beginning. And again, local partners and individuals with disabilities play a really critical role here. And that we've just got to have really specific instances of barriers. It's, this exact page of the website and this button, it wasn't screen reader accessible. And so, we get sort of, monitoring reports either from defendants or from a third party monitor that we've agreed on. But the informal sort of monitoring reports that, come into us from the disability community about, we just had an election and this is what happened. Those are the things that allow us to sort of enact dispute resolution and follow up. And, the specificity is what is, really important. So hearing about those real life experiences on the ground. So again, the right to vote, privately and independently impacts, all aspects of American life. And it's a right afforded to all of us. And we are here to keep fighting for that right. And I think at that point, I will turn it over.
No, thank you, Rebecca. You covered a lot of ground, and David has also a lot of ground to cover. So please, David, take us away. Thank you.
Thanks, Hezzy, and I want to thank everybody. I want to thank TASH for the invitation, and Cheri for all her years of advocacy at the Georgia Advocacy Organization. And I will sort of highlight some of the things also that Rebecca had mentioned as I go through some of the information here. As Cheri said, I'm with the National Disability Rights Network, and we are the membership association for the Protection Advocacy Network, such as a GAO, such as all the disability rights and disability law centers that exist in states across the country. So I want to talk a little bit about, in my 15 minutes, about how one, disability is used as a way to sort of restrict the vote of others, as well as things that advocates can look out for as we see other attempts by states and election boards to restrict the vote of people with disabilities specifically. And what is sort of amazing to me is, despite the fact that we've had accessibility laws on voting for 40 years, with the voting accessibility for the elderly and handicapped of 1984, and even 32 years since the ADA, there are still routine themes that will come back, and there will still be similar issues that we seem to have to keep advocating for and seem to continue to be vigilant about. So let me talk first about a report that we did, that NDRN did back just before the pandemic, released it actually in January 2020, that looked into the issue about using the ADA as really an excuse to close polling places and to restrict the places where people can cast their ballot. So this report came out blocking the ballot and ending misuse of the ADA to close polling places. And in the report, we talk about, first of all, how inaccessible, despite this 40 years since the VAEH was passed, how many polling places remain inaccessible parking, inaccessible aisles to get to the parking or get to the voting place, inaccessible doors, inaccessible sidewalks, just a lot of just basic physical barriers that prevent a person from even getting to the polling place to cast their ballot. And so we discussed it in some cases, depending on the sample and the methodology, anywhere from 50 to 100% of polling places, and this is in between 2015 and 2018, at that time were still found to be inaccessible for various degrees. So there was still a huge problem back 5 years ago with just physical accessibility. But then election officials were using accessibility issues as a reason to justify closing polling places. Probably the most egregious was actually in Cheri's home state of Georgia, where Randolph County cited the ADA as the reason they were going to close 7 out of 9 of their polling places. So, well over, almost 2/3 or more than 2/3 of their polling places, they were using the ADA as an excuse, saying they're all inaccessible and therefore we have to restrict the voting. Randolph County was probably the most egregious, but they weren't the only ones. So in McLean, Texas, in July of 2018, the county cited cost, saying that it would cost $100,000 to make one of their polling places accessible, and they wanted to consolidate some of them because of the cost of making places accessible. In Baker County, Arkansas, they also used the ADA and costs as an excuse to close 11 of 22 of their polling places. Actually, 10 of them, they specifically said, was because of accessibility issues. And then in Richland, Ohio in 2015, after the Secretary of State found that that county's voting places were highly inaccessible, the county said, well, the state is mandating all these issues. We don't have the money to pay for it. So again, they were then using sort of the accessibility cost. What is sort of distinct about these issues is that, or these examples, is that in several cases, including in Randolph County, there was no public evidence provided about the cost estimate. There was no information provided about where they came up with their estimates for why it could not, the counties and the Board of Elections could not make these places accessible and why it was so expensive. So that's sort of a point of advocacy as you're out working on this issue, is to pressure your public officials about where they came up with their estimates and why they cannot do temporary accessibility issues if they're unwilling to make, as they really should, the location permanently accessible. So that's an area to push back on. Another area, and probably one of the biggest concerns in today's climate, is using the ADA as a reason when there's other reasons behind why they want to close the polling place. So you want to look at why are they targeting that specific area? Why are they targeting that polling place? Is it really accessibility, or is it because of the voter makeup in that area? That was pretty clear, I think, in the Randolph County situation, highly African-American county, closing the vast majority of the polling places. So you want to sort of get to the demographics about why they're actually claiming accessibility in that specific area. So other areas in terms of the physical accessibility and how you can advocate. So the Department of Justice had been, and I believe it's sort of wrapping up again, some of their work in trying to arrange settlement agreements. So they had, prior to the pandemic, settlement agreements with Chesapeake, the city of Chesapeake, Virginia, McKinley County in New Mexico, Harris County in Texas, to try to resolve those accessibility issues and keep those polling places open. I know PNAs in Illinois, Equal for Equality, Disability Rights Arkansas, and the Baxter County issue. In those cases, the jurisdiction actually actively worked with the PNA to try to come up with solutions. So you want to encourage the Board of Elections, if you can get in early enough, to say, hey, why don't you work with the disability organizations to come up with solutions? You may think it's $100,000. We are experts in accessibility. We may be able to find ways that can make that place accessible for a much more cost-effective way. So those are the one area that we've been sort of tracking for the last 5 years. Another area that Cheri sort of mentioned a little bit and talked a little bit about guardianship issues is what I'll classify as sort of a categorical exclusion based on disability. And it's sort of interesting how far back some of these cases and how they seem to keep cropping up. So for example, in 1975, Massachusetts was successful in some plaintiffs in Massachusetts were successful in preventing a Board of Election from refusing to register people who had intellectual disabilities and were living in ID facilities. So the Board of Election said, no, this is where you live, you probably can't vote, and therefore we're not going to allow you to register, even though they were not under a guardianship, and a court said, no, that violates state law. Around the same time, New Jersey had a very similar case where there were students at a state school for intellectual disabilities and they wanted to register. And again, the county board in this county in New Jersey said, no, you live in the state school for people with intellectual disabilities. We don't think you can vote, even though there had been no court order or any other indication that they could not vote. And fortunately, in that case, the state court also overruled that. But then you jump 25 years and it happened again in New Jersey. So as recently as 2000, at a psychiatric hospital, a county board attempted to prevent ballots from being counted, absentee ballots from residents of the psychiatric hospital, claiming that those individuals were not eligible to vote. Many of the individuals that voted had not been under a court order, that they were under a guardianship, or a court had not ordered that they were, quote, incompetent. And therefore, the court in that case said just because they were residing at the time they cast their absentee ballot did not mean that they were ineligible to vote, and ordered the court and the county to count those votes. In 2008 in Rhode Island, a Rhode Island county attempted to prevent people who had been had been criminally found not guilty by reason of insanity in a criminal case, and claiming that those individuals could not vote based on that determination. And again, fortunately, there was a settlement agreement because the court was leaning toward the case that it was not, they were not under guardianship, and just because they were not guilty by reason of insanity was not an adjudication that they had lost the right to vote. So in that case, fortunately, also after court intervention, they were able to resolve that situation favorably. But a month and a half ago, this happened again. This happened in, this situation happened similar in Missouri. So in Phelps County, the county clerk had planned to remove all people from the voting rolls who had a guardian appointed, whether or not a court had individually found that those individuals had lost their right to vote. And the county clerk in June of this year said, how is a person unable to manage their own financial affairs? How can they be allowed to vote on someone else's taxes? You have to think about it. People who are working hard, paying their taxes and voting, where are their rights? Elections can be won or lost on one vote. Well, of course, that's true. They can be lost in one vote. But how about all the people with disabilities under guardianship who are working and earning taxes? So fortunately, she backed down, but she backed down under pressure from the county and from the county and the state Secretary of State. But it's still prevalent that even in 2022, there are still people who think that just because you have a guardian or just because you have a disability, certain types of disability, that you should not be able to vote. So fortunately, we're still beating these back, but we still have to be vigilant of those. There's also a case, and for the sake of time, I'm not going to go too far into it, but for those that are interested, there was a very good case recently in Oklahoma where advocates were under a guardianship and they were prevented from voting. And this is one case of an individual in Oklahoma who had voted for a while. He moved counties and the new county refused to allow him to vote because he was under a guardianship. And there was a good 60 minutes broadcast about this case. He, fortunately, at the end of the video, before the state law was changed, says, I'm confident we can change our state law in Oklahoma. And 2 years, about a year later, there was actual success where guardianship does not automatically result in a loss of a vote, and the court has to affirmatively make a determination that the individual is no longer eligible to vote, which was a good win in Oklahoma. I want to sort of highlight in the last sort of 4 minutes that I have left here, two very recent cases that came out involving Section 208 of the Voting Rights Act. So as you may or may not know, Section 208 of the Voting Rights Act provides that any voter who requires assistance to vote by reason of blindness, disability, or inability to read or write may be given assistance by a person of the voter's choice, other than the voter's employer or agent of that employer or officer or agent of the voters' union. So essentially, except the employer or a union, the individual with a disability under Section 208 has the right to choose who they need to offer to provide assistance for them to vote. Two decisions have come down this week with definitely different opinions. One came out of the Wisconsin Supreme Court. In that case, there is a provision of Wisconsin law that says regarding absentee ballots that the ballot shall be mailed by the voter or delivered in person to the municipal clerk issuing the ballot or the ballots. Now, the case did involve the use of drop boxes, so there was a lot of discussion on the drop box issue, but there was also the issue about whether or not an individual could choose who they wanted to mail or drop that ballot off. The court's case is a little confusing. They basically said because the defendants in this case did not prosecute or adequately argue the issue about whether Section 208 preempted this provision that only the voter could deliver the ballot in person or mail the ballot, that therefore they did not think that the Wisconsin law was preempted by state law. It's a little bit of a confusing decision, excuse me. I still think that Section 208 will trump if other cases are brought in this case. I think the decision is only in a few paragraphs related to that, but unfortunately they did not find that Section 208 trumped this provision of Wisconsin law. 2 days ago in North Carolina, so Rebecca is one of her home state, a very good decision with an opposite conclusion. In North Carolina, there was a provision that essentially said that only a near relative or a legal guardian could assist an individual request an absentee ballot mark that ballot or mail or deliver that ballot. So essentially the legislation said that an employee, an owner, a manager, so basically a person working at a facility, if the person was in the facility, or another person other than a near relative or legal guardian could not assist that individual in marking the ballot, asking for the absentee ballot, or delivering the ballot once it was executed. Fortunately, the federal court in North Carolina basically said that Section 208 preempts this law and ruled that it was invalid, struck it down not only for individuals with disabilities, but also, for individuals in facilities, individuals with disabilities in facilities, but also individuals with disabilities who were living in the community. So it basically said that those restrictions they could not impose those restrictions on people with disability on their choice of who they want to vote. So kudos sort of the Disability Rights North Carolina for that very recent victory. So just in my last minute here or so, I just want to give you, some additional ideas. I think Cheri mentioned, filing complaints. So filing complaints with the Department of Justice, work with your P&A. You certainly can do it on your own, but the P&A is available to assist you with filing complaints to the Department of Justice. Volunteer maybe. So for example, Chicago had a number of volunteers back a few years ago who went out to look at polling place accessibility. So if that's an opportunity and the P&A offers that program in your state, you may want to volunteer to look for accessibility issues. And as I said, work with your officials, your election officials, work with your public officials to ensure that the laws are ensuring that people have the right and the accessibility that they need to cast their vote. So with that, I think we're going to leave it up to some questions after that. So I'll sort of conclude there.
David, Cheri, Rebecca, thank you not only for sticking to time and being timely, but bringing so much to bear. I'm going to kick off our short Q&A session with a question that came through in the chat earlier from Matt McCullough. And it was on the topic of, voting electronically and balancing those security interests. There might be cybersecurity related concerns when accessing electronic means or online means for voting. But at the same time, as I think, Rebecca, you mentioned, there are other groups of people that use online voting or electronic voting, and why can't those systems be expanded to include people with disabilities? And so if any, I'm going to just open it up to Cheri, David, and Rebecca, if you have kind of thoughts on just talking points that disability rights advocates can use that might push back on cybersecurity related concerns with regard to creating more electronic voting options or expanding those existing options to disabled voters so that they can access the polls. Does anyone want to grab that?
This is Rebecca. I am no IT expert, but I will say what I know about this, which is I feel like that's a very common, whether we're in my line of work, whether I'm advocating for somebody to be able to take a test, with their assistive technology that's typically a paper and pencil test. There's always, we always get the, oh my gosh, we can't do this accommodation because of, we're going to put it on the computer and then it's going to, cause a security problem. But plenty of entities have worked this out and found ways to do this securely. So, we've just continued to push and, get the engineers at the table to help come up with the solution. And it's kind of, I think that's about what I've got on that one, but it's got to push people to think creatively outside the box to, make sure these systems are working, and the technology can really open up a lot of avenues, especially for people with disabilities. I think the pandemic has taught us that for sure. But sort of balancing that with security is something that can happen, just takes the right folks.
Thank you. And I think, kind of, oh, sorry, David, go ahead.
Okay, yeah, no, I was just sort of the piggyback on Rebecca is their security has always been, an issue with voting. So they've used it with, even the current voting systems, or, there's always a push-pull with security. And I think advocates have to continue to say, look, you have to consider the disability part of this, because if the security and IT people will go their way and there's not the advocates, keeping in that fight, as Rebecca mentioned, it's going to get lost. So I think we're sort of in terms of if the security can work, and this is a way to ensure accessibility and equal access to vote, then, NDRN, supports that.
Thank you. Rebecca, I wanted to ask you, kind of in response to some of your remarks, you described a number of cases that the DRA has brought. How did those cases come to the DRA, right? And, with a specific view to, just providing some specific examples in the current electoral environment of how folks might approach in a successful way organizations like DRA or their state's protection advocacy organization. What is it helpful to have, and how do you make that approach so that organizations like you can put those issues to the test in the courts?
I think that's a great question. I think our cases have come to us in a variety of ways, sometimes through emails and phone calls from people who are Googling about what I had this problem with accessible voting, and then sometimes the P&As that we have partnered with have reached out to us to say, we've got this problem in our state. Looks like you all have done some work in this area. What do you think? And we talk to them, and and then some instances end up co-counseling together. So that's kind of but it all goes back to people with disabilities sharing the discrimination that they experienced, and reaching out to attorneys.
And Cheri and David specifically, you're both in organizations that, Cheri, you're on the ground, you're doing training, you're doing voter outreach. David, you're coordinating at a different level, a national network of organizations that are doing that good work. What issues in this current election cycle with regard to voters with disabilities are kind of worrying you or keeping you up at night, and that advocates should be keeping a sharp eye out for and report to organizations like their protection advocacy groups?
So I'm going to say this. There's a lot of stuff going on, from nursing facilities using the BIMs to determine whether or not a person can vote. I don't understand how they have the right to do that. To a lot of things. It can feel a bit overwhelming at times because there's so much going on, especially since the presidential election.
Thank you, Cheri. And I noticed that we just got a question, David. I don't know if you could touch on it before we wrap, but specifically with regard to brief interview for mental status scores. Have you been seeing those, or should we be on the lookout for those used to determine whether one should be allowed to vote or not? If you're comfortable speaking to that.
I have not seen that directly, but I would definitely be concerned. I mean, you want to know, I think we put it in the chat, what your state law is, but I don't think there's any state. Usually, if it's going to be a restriction, it's going to be after a court order guardianship. So using any type of, without a court order, that says this person, is under guardianship, is quote unquote incompetent under the law, and your law automatically, restricts the vote at that point, then be wary of any type of capacity from anybody other than a judge or a court order.
Yeah. Well, thank you all once again so much. We've reached our time, but I've learned a whole lot. Rebecca, Cheri, David, thank you so much for sharing a little bit of what you know, and keeping us all vigilant for the issues that we should be looking out for. Thank you guys so much. And I'll turn it over to Matt, our MC.
Thank you, Hezzy. First of all, I want to thank all the panelists, Rebecca, Cheri, and David. Your information was tremendous. The fact that we constantly are being prevented to exercise our civic duty during these elections. We need to continue pushing those rights and making sure that we have access at the polling locations and so forth. So I want to thank all of you for your leadership. We are going to take a 15-minute break, ladies and gentlemen. We have our third panel coming up at 3:45 p.m. Eastern Time. The panel will be addressing education. The theme for it is closing the gap, advancing inclusive education. So please come back at 3:45 p.m. Eastern Time. You don't want to miss it. It's our final symposium panel for the day. See you soon. Take care. Bye-bye.